Continuamos con nuestra presentación. Ahora tenemos la presentación de persecución, persecution without discrimination. Y después tendremos los closing remarks, que son, que I understand that it is going to be Juan Antonio and Congresswoman Liliana Rose-Lettinger. So, without much other ado, I will invite Sebastián González to please come to the podium and present the case of persecution without discrimination.
Thank you very much for having me today. It's a pleasure to be here amongst such distinguished colleagues. I will begin by saying that the case that I've analyzed in my paper is one, as we can see, that is reminiscent of many other cases in Ecuador throughout its history. Sadly, it has also been the case in other governments, not only in this one, and it has also been a recurring situation in other Latin American countries as well. As a background to this situation, we can see that the Ecuadorian government has had a very highly confrontational relationship with civil society in general, and in particular with civil society institutions. And there are several elements that have developed through this confrontational relationship. One in particular that is directly linked to the case that I have analyzed is the use of military and police to dissuade public demonstrations and protests. In the specific case and in general, there has been an excessive and disproportionate use of force by these state agents. And it may surprise you to hear that the military has participated in in the prevention of these protests. But the government has justified their participation. It has said that it is necessary, and it has even led to an amendment to the Constitution last year, which now mandates the military for internal security. Another important element of this relationship between the government and civil society has been the use of the criminal justice system as a deterrent. As we can see, as we have heard throughout the speeches this morning, the criminal justice system has been used by the government to deter public protests, criticisms in general, in all aspects, even in social media. In this case in particular, the Saraguro community, which you may have heard of before, since it has been part of several cases, not only in the internal justice system in Ecuador, but also in the Inter-American Commission and in the Inter-American Court, participated in a nationwide call to protest in August 2015. This community located in the south of Ecuador in the province of Loja came out peacefully to protest amongst several issues, particularly cultural and environmental issues. And during this protest, as I had mentioned already, the military and the police were called out to stop, to prevent the protest from occurring. And they used batons, they used tear gas, they chased and cornered the people who were protesting, and even went into their private property. 31 members of the Saraguro community were detained, and they were charged by the prosecution. And the judge accepted a request by the prosecution for private detention, for pretrial detention. And the other thing that may surprise you is the crime for which they were charged with. It is one that has already been mentioned this morning. It is the crime of stoppage of a public service. And in Ecuador, it has been common to consider that blocking a public road, a highway, for instance, in this case, the Pan American Highway, is considered a crime that is to be sanctioned between 1 to 3 years of imprisonment. And so here we have yet again the conflict between several constitutional rights and criminal law. And as we have seen in this case, as in others that have been presented this morning, there has been a situation where the constitutional rights have been subjugated to criminal law. How can the constitutional rights of assembly, resistance, and to demonstrate in public, the right to demonstrate in public, be exercised if the citizens are not allowed to be in public, be it in a road, for instance? I don't think it would be able to be exercised in somebody's backyard. It has to be in public. So these constitutional rights have been, by the judges, by the tribunals, by the courts, been subjugated to other more important criminal punishments. And another element of the case that is very important and that is also reminiscent of other cases is the use of preventive detention. As one knows in international law, as in Ecuador, it is a measure that is to be used exceptionally, and it should not be provided by the judges so easily. There are certain requirements that must be met, and in this case, obviously, this did not occur. All those that were detained lived in the same community. They worked very close, and obviously, they were not a flight risk. The government participated very actively in the case. They presented complaints against the 31 detained, and therefore they initiated a private prosecution during the case. They requested witnesses, they presented written arguments, and they designated 3 attorneys to the case. Obviously disproportionate to the situation as well. The state attorney and the province governor, which is the representative of the executive in the provinces, participated also. They were called to the hearings by the judicial authorities, and obviously it demonstrates that the government wanted to be kept informed of the case. They wanted to actively participate during the proceedings. And obviously, given this interest by the government in this case, there were procedural irregularities. For instance, one that is most important is that the local prosecutor had absolved. It decided not to charge most of the 31 detained. And this, in a matter of a few hours, was revoked by the superior prosecutor, the provincial prosecutor, and he decided to reinstate charges and revoke the decision not to charge many of those that were detained. There is then a logical conclusion that there was a certain compliance by the prosecution and by the judicial authorities to provide favorable decisions for the government. They knew that they were watching, they knew that they were listening. And obviously, you might think that even though in the end, in my paper, I conclude that many of the detained were not sanctioned in the end. There is a possibility of appeal. But as we have mentioned this morning, there is the situation in which those that have been detained may have already been sanctioned on their own. They have passed through a very torturous procedure. They have been detained preventively. There is a situation of social criticism, and obviously their reputation in some way has been tarnished, even though they may not in the end be sentenced by a judge. So in conclusion, we can have several ideas. The first is that the government has been intent on impeding protests. There has been an abuse of the judicial system, specifically of criminal prosecution, and obviously this is inadequate. A constitutional state that Ecuador wishes to be, that it means to be, needs separation of power, legal security, and the respect for the authority of the judicial system. And as a main conclusion, we can say that Ecuador should abandon the practice of using malicious criminal proceedings for political purposes and embrace the principles of a modern democracy. Thank you very much.